Turn next to item 2. This is case number 358922, People of the State of Michigan versus Carl Thomas Masi.
Morning, Your Honors.
Morning.
Alona Sharon on behalf of the appellant, Carl Masi. I will try to adhere to the very diplomatic comments of Your Honor to keep comments short. I've been here enough times to know that Your Honors are all very familiar with the briefs and the arguments. As it relates to the first argument in the brief on appeal and the trial court's error, and that it abused its discretion where it denied Mr. Masi's motion for reconsideration to admit various pieces of evidence. I just want to touch on a few points. First of all, as it relates to evidence that we seek to admit that some of the complainants had the opportunity to watch various pornographic films, whether it was with Uncle Robbie or on their own prior to their adoption by Mr. Masi. I think there's just a couple important points. One is that this type of conduct is not subject to analysis under Rape Shield. That's a point that was made in the brief. I think the recent decision under Sharp makes it very clear that this type of conduct is not subject to analysis under Rape Shield. I noticed in the prosecution's reply that argument isn't really addressed, whether or not it falls under Rape Shield. So I'm not really sure what the prosecution's position is on that, but I think Sharp, the case law on that is very clear that the conduct isn't analyzed, or the admission of this evidence isn't analyzed under Rape Shield. But more importantly, is that the trial court recognized in its ruling the relevancy of such evidence, and the trial court's language as to recognizing the relevancy is quoted at page 14 of our brief. And also, I just want to point out that the Morse case is not relevant when analyzing admission of this evidence, because Morse, again, is a Rape Shield case, but also it talks about it's analyzing the admission of sexual conduct of a complainant or a victim, not something like watching pornography. As it relates to the complainants seeing pornography prior to their living with Mr. Masi, it's critical to a case like this where you have young children who are displaying advanced sexual knowledge for their age, and there has to be an explanation for that, right? Either they have this advanced sexual knowledge because these horrific allegations are true, or they have this advanced sexual knowledge because they're getting it from somewhere else. And there is a plethora of evidence that they have other sources for this sexual knowledge, whether it's their allegation that Uncle Robbie showed them pornography, right? Interrupted the viewing of cartoons to watch pornography, that he watched pornography with them, or that they watched pornography on their own. These are young children, and there has to be a source for their knowledge. And the fact that we have a significant amount of evidence that they were subjected to pornography, that they viewed it, is an alternate explanation for why they have this advanced sexual knowledge, and it is a critical part to the defense theory going into trial. So given the fact that the trial court in its statements—
I have a question, but I'll let you finish.
Given the fact, thank you. Given the fact that the trial court recognizes the relevancy of this information, of this evidence, that there is a significant amount of it, that it is not subject to Rape Shield analysis, I believe that the trial court erred and abused its discretion in ruling that this evidence is not admissible. Your Honor, did you want?
Yes. Okay. All right. So since we're on the subject, I'm trying to parse out the evidence of pornography that your client is seeking to admit.
Sure.
So we have evidence in the context of the prior sexual abuse by the uncle, that the uncle showed AU pornography. And then we have evidence that SU watched pornography with the defendant and on her own post-adoption because she was caught by the stone. Is that correct?
Okay. I don't think there's any allegation. So let me start with Uncle Robbie.
Okay.
you are correct that there's allegation that AU watched pornography with Uncle Robbie, and that Uncle Robbie showed her pornography, I think, on a number of occasions. And that would all, right, predate Mr. Massey's adoption of these girls and before they came to live with him. So certainly, I think that is relevant. And I think the trial court recognized that relevancy. Then I think Your Honor mentioned an allegation that SU watched pornography on her own.
And with the defendant.
I don't believe that there's an allegation that she watched pornography with the defendant. If I'm misspeaking, I apologize, but I didn't believe that that there was evidence that she watched pornography. There was evidence that AU and SU have watched pornography without prompting by Mr. Massey. That is something that the defense wished to introduce. Now, SU's watching of pornography, and I believe that she got caught watching pornography. I would concede that the timing of that is somewhat vague in the record as to when that happened, whether it's pre or post living with Mr. Massey. But certainly AU's watching of pornography, I think there's no doubt that that predates Mr. Massey's involvement.
Okay, and I have a follow-up.
Sure.
So without evidence that the complainants were specifically exposed through pornography to the sexual acts charged against defendant, doesn't the evidence have minimal probative value at best? And why isn't that substantially outweighed by concerns about misleading the jury with extraneous issues or unfairly prejudicing the complainants?
Sure. So I think as it relates to AU, the evidence is clear that her observing of pornography with Uncle Robbie absolutely predates Mr. Massey. So to that extent, it's absolutely relevant to explain why a child this young would have sophisticated sexual knowledge. And so I think it's highly probative, and I don't think it's prejudicial, and I don't think it would confuse the jury.
But
Yes.
sophisticated or advanced sexual knowledge leads to what inferences here? As it relates to these discrete allegations of criminal sexual conduct, how does advanced sexual knowledge by a minor, and what inferences then are we arguing to the jury?
Sure. I think the argument, Your Honor, is, well, how does a 10 or 12-year-old know what sexual activities are? How do they know what oral sex is? How do they know, that sex is essentially a penis going into a vagina, or that these are common sexual practices, or that ejaculation is part of sex, things like that. These are not common acts that a 10-year-old is going to be familiar with, or a man rubbing on a woman's vagina. This isn't, I don't know, when I was 10 years old, I certainly didn't know about these things.
I'm tracking that part of it. I
Right.
guess the question I have is, even if we acknowledge that, okay, if they're looking at pornography on their, isn't it possible that they're looking at pornography on their own and getting sexual assaulted?
It is a possibility. That's certainly a possibility, but it's also a possibility that their description of these events are that they can describe these events, right? Because they've seen them somewhere else. Because I think what's important to remember is that another part of the aspect of the defense in this case that the trial court agreed can come in, right, is that these children over time had expressed a desire to not live with Mr. Massey. They wanted to live with it was a cousin or an aunt. And they had expressed that, there was a record of that, and that can come in at the trial, right? Because they had perhaps a motive to accuse Mr. Massey of something so that they wouldn't have to live with him, and that they could live with this other relative who they preferred. And that is going to be admissible at trial, right? So you have to think of sort of the defense theory as one whole part and parcel. So if part of the defense theory is going to be, well, these young girls wanted to not live with Mr. Massey, but instead with a relative, okay, and now they have a motive to lie about allegations against him. Well, where are they getting these details from, right? How do these girls have this knowledge to concoct believable sexual allegation details? Well, is it because they were actually victims of sexual assault, or is it because they have this knowledge from some other source, such as pornography?
Would you agree with me that when Uncle Robbie showed the child pornography, that in and of itself was a crime. Namely, sexually abusive material to a
Sure.
minor. You'd agree with that?
Sure, yes.
Why then, at least in terms of Uncle Robbie, would we not have to analyze this under 404B, right? Not the traditional 401, 403 analysis.
404B as it relates to the complainant?
Yeah, I mean, we're talking about a
As a-
prior bad act, right?
That
Right?
the child?
That- No, this was a crime that took place, right?
Well, but 404B is propensity evidence as it generally, you're trying to show.
Oh, I see what you're saying. Yeah, I got it a little backwards, don't I? Right? Because if it's not the complainant is, right,
Well,
okay.
it's not just that, but I mean, respectfully, 404B is when you're trying to show the propensity of someone to engage in this.
Sure,
And here we're just trying to show it as a possible source of,
no, I get that, I'm
Right.
trying to figure out, I'm assuming I agree with you that the rape shield doesn't apply. The analysis, as I understand your argument is it's a 401, 403 analysis.
well, I think.
Is it relevant and is there the danger of unfair prejudice substantially outweighed?
Well,
right?
and I think it's also a right to confrontation. I think at its core, right, it's a
Sure.
constitutional claim. And I think that the rules of evidence must bend to a defendant's right to confrontation where we
Right.
can demonstrate.
As long as it's relevant
Yes,
and as long as it's admissible under 401 and 403.
yes, Your Honor.
Okay.
Yes,
Right.
and I think that given the weight, right, and the multitude of evidence here about the pornography, it certainly can meet 401 and 403. And therefore, those rules must bend to Mr. Massey's right to confrontation and to present a defense. I mean, he has due process right to present a defense and a Sixth Amendment right to confront his accusers. And not allowing this evidence in hampers those rights. It essentially robs him of those rights. Are there any questions as it relates to the pornography or? Okay.
Go ahead.
As it relates to the evidence about the sexual assault by Uncle Robbie of AU. So first of all, it is the same sexual act, right? Because AU alleged that Uncle Robbie forced her to commit oral sex on him, and counts 1, 5, 6, and 8 in Mr. Massey's case all relate to allegations that AU was forced to perform oral sex on Mr. Massey. So we do have the same sexual act in multiple counts of the information. So this brings us to the cases of Arenda and Morse, right? Because this analysis is subject to rape shield. So I just first want to stress, right, that rape shield, it is not a complete bar to this type of evidence. And Arenda and Morse both recognize that this type of evidence where we have young complainants, it is sort of the poster child for where this evidence is going to have a probative value. But what I think is most important are 2 points that I want to address each Arenda and Morse. First of all, Arenda is really factually distinguishable. And I'll admit, I had kind of forgotten this until I reread the case early this morning, that in Arenda, the defendant was able to question the complainant in that case about other sources of sexual knowledge. The defendant was able to ask the victim if he ever saw friends or others engage in similar sexual acts. And the defendant was asked if the defendant was able to ask if the victim engaged in these sexual acts with others and received an answer of no. And the decision also indicates that an additional third question was asked that the victim answered no to. Also in Arenda, the opinion makes clear that there was no evidence to suggest that the victim in Arenda had been a victim of another sexual assault, right? So all of these facts taken together, number one, are facts that the court relied on in its decision in Arenda, but more importantly, make Arenda really remarkably factually distinguishable from this case because, well, number one, we're pretrial. So no one has had an opportunity to ask these complainants anything. But more importantly, we do have a quite significant amount of evidence that AU was a victim of sexual assault at the hands of Uncle Robbie. We do have reports where she details him placing his penis in her mouth, her not liking it. I don't need to, your honors are familiar with the unfortunate details. So to that extent, Arenda is miles apart from the instant case. So, so then we turn to Morse, right? And here's the problem with Morse. Morse talks about cases from other states and the tests that they apply and looks to them with favor. And specifically, this was Wisconsin versus Polizano case, which and it lays out 5 factors, right, that the court should consider if it's going to admit this type of evidence. And one of the factors is that the prior act clearly occurred, right? That's going to be one of the factors that we have to look at. Somehow, and this is also cited, I believe, by Mr. Saman in his brief, somehow when the Morse case or court, after reviewing these standards, comes to a determination that there has to be a conviction in order to allow this evidence of a prior sexual assault come in. And there's no explanation in Morse how it goes from looking to this Polizano case that the prior act clearly occurred and now there has to be a conviction. And I would argue to this court that it's wrong, right?
It's a published case though, we got to follow it. I'm not tipping my hand whether I think it's wrong or not. I've always been struck by that, but it's a published case, we've got to follow.
Okay, so
explain to me why we don't follow that published case and that requirement.
aside from the fact that
Other
it's
than it's
wrong
wrong.
and I don't like it,
Right.
and I just want to stomp my feet and say it's wrong like a 5-year-old, because I'm going to be 44 in a few weeks. So aside from that, because I know it's not going to work, I will return to my argument, right, that Mr. Masi has a 6th Amendment right to confront his accusers. There is ample evidence that this sexual assault occurred. He has a due process right to present a defense. He has a 6th Amendment right to confront his accusers. Keeping this standard that you don't even require a prior conviction to admit prior bad acts, not of sexual assault, not of domestic abuse, but you're going to require that a conviction has to have occurred for a defendant to enjoy and wrap himself of the protection of the 6th Amendment and due process. It is a ridiculous, respectfully, standard for a defendant to have to meet, because there can be a multitude of explanations of why a conviction never occurred. It can be that a parent failed to report it.
Get it.
Okay,
get it.
I'll stop. To make that the standard and deny Mr. Masi the ability to present this evidence where there is significant evidence that this child was subjected to a sexual assault denies him 6th Amendment rights and due process rights to a fair trial and to present a defense. It is an unreasonable standard, and I think it is reasonable to conclude that the Morse case, I keep wanting to say Morse code, made a mistake, because it clearly approves of the test in Wisconsin versus Polizano, and then takes this extra leap, extra jump, without any explanation of why it's making the test harder than the test it approves of, 1 paragraph up in its decision. So I will leave it at that because the stomping of my feet isn't going to work. As to the rest of the arguments in argument 1, I will rely on my brief. As it relates to argument 2, I called Mr. Saman yesterday and said, it feels so weird to prepare for oral argument, and I feel like the panel knows more about the record than we do because we've never seen these privileged records. So I will just say, obviously, our main goal as the appellant was to have your honors review those privileged records. It seemed inexplicable that these records the trial court's finding that these records do not contain evidence and material relevant to the defense, given so much of the peripheral material that we did have access to. I would just argue to this court that if the privileged materials that your honors have reviewed contain evidence about the complainant's counseling for repeated problems with lying, counseling about sexual assault by Uncle Robbie, evidence of trauma, they are absolutely relevant to the defense, and that the trial court abused its discretion in failing to turn those over after its in-camera review. But other than that, I can't really say anything because I haven't seen them. So, Your Honor, we ask that the court find that the trial court abused its discretion in denying the motion for reconsideration. And I would reserve, I should have at the beginning, a few moments for rebuttal. I'm sure I have.
You've got plenty of time.
I've got actually just two quick questions because I want to ask the questions before.
Of course,
we
Your
hear
Honor.
from you.
Sorry.
Two quick questions. In terms of how are you going back to the pornography issue?
Yes.
How are you going to introduce that at trial? Uncle Robbie's not going to testify.
Right.
Police reports are all hearsay. I imagine the only way you could get it in is through cross-examination of the complainants to
So-
ask them whether in fact they did, and they'll either admit it or they'll deny it. Is there some other way?
So as I think Judge Garrett testified, there was an incident where one of the children was caught watching the pornography. So whoever caught the child could
I
testify
thought that
to
was
it.
the defendant.
You're right.
That was the defendant, and
Right.
he may or may not testify.
Right. So obviously questioning of the child. Also, though, there was at least a CPS report that was made. Obviously the report is problematic. I don't know if the CPS worker, I can't imagine that. would be
Probably through the
admissible.
child. So that relates to my second question.
Sure.
And last question.
Yeah.
And it seems to me that with regard to the pornography issue and the advanced knowledge of sexual activity, right? Either one of those situations would fit the bill for purposes of knowledge, right? In terms of what the child knows, the child shouldn't know if it hadn't been for the pornography. So it seems to me, if I was sitting where the trial court was, I would be, even if I accepted your argument, I would give you one, not both of these viewings of pornography. One, either the one with Uncle Robbie or the one with where your client walked in, right? Those are the two situations I think that you hope to admit. Which of those two has the greatest probative value in your view?
I think certainly the ones with Uncle Robbie because of the timing of it, right? The
Before the adoption.
yes.
Okay,
Yeah.
that's what I need to know. Okay, thank you.
Any other questions? Okay. Response?
Morning, Your Honors. Emil Sama on behalf of the people. Many years ago, before COVID, I was handling a case with another defense attorney where I agreed to restore his appellate rights under the previous version of the court rule. And I conceded that it should be restored. And I remember coming up to this court to make the argument. And when the opinion came out, they rejected my concession and basically said the prosecution, the parties cannot concede an area of law. I bring that up today because I am at this point agreeing with sister counsel. I think the Morse court got it wrong. I really do. Because when you look at Palooza, and I'm going to start with Uncle Robbie because it goes to the pornography issue. The Morse court requires there to be a conviction. That seems like a strong leap from where the Polizano case came out to play. From where the 5 framework came out to a 3-part test by Morse requiring this conviction, which is contrary to case law with dealing with 404B and 768 and every other situation we have with other acts. And there is a part where the competing interests in Morse tried to deal with the competing interests of the right to present a defense with also the right to protect the victim and other victims with dealing with this type of information. So I know it's a published case. I know we're bound by it. So by that rule alone, I win on all the Uncle Robbie arguments because the trial court was bound to follow that rule. And they were bound to keep out anything that didn't result in a conviction. I think it's a hollow victory. I think the court does have an ability through a conflict panel to address the Morse decision. I think it probably should, because all of this precludes a true analysis by the court. Because based upon the fact that there's outline, we have, as Sister Counsel admitted, the timelines are vague. Some of the factual questions are vague. The pornography issues are extremely vague. You have the one with potentially Uncle Robbie or the one with the defendant Masi. And if the one comes in with Uncle Robbie, it's a crime. Child sexually abusive or immoral or solicitation, and there's a whole bunch of crimes that come with showing a child pornography, which then goes to the improper knowledge, which again goes under the Morse factors. All of this comes into play. And I think that all of us are at a very, very unsteady precipice of trying to parse out the facts without realistically having an in-camera evidentiary hearing, which we really can't have because there was no conviction.
So what's your position on the watching child pornography? Is that under the rape shield
I
statute?
think it's under the Morse framework, the Morse surrender, because
So you're saying it does fall under the rape?
yes, because the allegation that she watched pornography, that Uncle Robbie introduced her to pornography, which in itself is a crime, and that led to the advanced knowledge along with the sexual assaults that led to the crimes of Mr. Masi. Because just watching pornography,
You're running through that too fast.
I'm sorry, I do talk fast. Uncle Robbie allegedly sexually assaulting the minors and showing them pornography is supposed to be the significant similar conduct that Mr. Masi would like to have done to these victims as well. He showed them pornography and sexually assaulted them. They are inextricably linked under their argument. Just to say a child watched pornography is not in and of itself evidence or the inference that this led to the advanced sexual knowledge. And I'm going to laugh at this because it actually became a defense attorney used a couple of years ago, the 50 Shades of Grey defense, where he actually cited the 50 Shades of Grey movie in his argument that that's where the victim got all the information to make up her allegations against the defendant.
So my question is more specific to the statute. Is watching pornography sexual conduct?
No, is an
If
adult.
it's not, then it doesn't fall under the rape
But
shield
an
statute.
adult showing a child pornography, which is what their allegation was with the Uncle Robbie allegation, was that Uncle Robbie showed her the pornography, then yes, that would fall under the criminal
Separate
section
from them watching it on their own.
that Mr. Massey caught. Okay, so that's the two
All right,
separate.
As I understand it now, it is sexual conduct when Uncle Robbie did it. It would not fall under the rape shield statute when it's the two minors in the room that access pornography by themselves.
When the defendant caught them, yes.
You agree with that?
I think I would agree with that, yes.
Okay. Got it.
Before we move too far past the whole discussion of Morse being right or wrong, I mean, since we're talking about it now, I guess, what's your response to if someone were playing the devil's advocate to justify Morse's holding, to say, look, the panel in Morse looked at Polizano, saw some wisdom in that basic framework, but to avoid having a trial within a trial, every single time this issue comes up, we're going to require there to have been a conviction so that we don't have this 403 issue in every single case. What's your response to that?
I agree that there has to be protection of that kind of information. And that's what the Morse court was trying to do. I agree the Morse court was trying to deal with the competing interests of both the victim and the defendant in this matter. And they did the best they could at the time. However, I think there's other safeguards that can be utilized without going, we can use a scalpel instead of a sledgehammer to get our competing interests into play. So does it require automatically to go right to conviction? I don't think that requires it. However, I think that given that this is a judicial framework, an argument can be made that there has to be a motion, that there has to be some evidence, kind of like what you would do a stand away, where you wouldn't just say, well, we just want to use this person. Well, give me something more. An in-camera review of records. And where there may be factual issues, an in-camera evidentiary hearing. That still protects the victim from doing this in open court in front of a giant live audience to be seen at the time. I've done several in-camera reviews where it's come into those situations where we protect and still get the information to have a record that we can at least work out with, where we have what I would say are wonky, vague timelines of when stuff was done and or seen. And I think that can sufficiently protect both the victim as well as the defendant's rights. So I think while Morse was trying to deal with those competing interests, it didn't need a sledgehammer. We could have used a scalpel.
Yeah, I mean, this is not a novel issue. The Michigan Supreme Court has seen this many, many times. They've elected not to overrule or even undermine that argument. I understand and appreciate the unanimity between the two of you, but from my perspective, that's not going to carry the day. So,
And that's usually why they won't usually accept a prosecutor's concession on the issue of law. And that's true. And that is true. I would say that if it's based off the idea that Morse requires a conviction, then none of the Uncle Robbie stuff comes in. The prosecution wins by that default alone, including the Uncle Robbie showing them pornography. Unless there's any further questions.
Nope.
Thank you.
Rebuttal?
Just briefly, Your Honors. Judge Cameron, to your question about the watching of pornography, if it falls under rape shield. If it's okay, I'd like to just briefly address that question. I would respectfully disagree with Mr. Swan. I think that the watching of pornography, whether it's with Uncle Robbie or the girls on their own, is not the type of conduct that is subject to analysis under the rape shield statute. I think the decision in Sharp makes that analysis very clear. And I think even just the plain language of the rape shield statute. But the way that Sharp looks at what the definition of sexual conduct is, the watching of pornography certainly would not fall under the definition of sexual conduct as it is defined by the Michigan Supreme Court in Sharp, whether it's on their own or with Uncle Robbie. The second thing I just wanted to address is Judge Hood in terms of the Morse court and, trying to avoid a trial within trial. I know that it's always a concern that I hear from judges and prosecutors of trying to avoid a trial within a trial. I agree with Mr. Saman that there are so many other ways to go about safeguarding and protecting the record and avoiding that concern. And also, again, the Polizano case, laid out 5 factors to try and avoid that concern. And there just is no explanation how Morse goes from approving this 5-factor test and then whittling it down to something so much more difficult for a defendant to meet and at the same time enjoy his constitutional rights.
Why not just take the whole test?
Yes. So with that, thank you for your time. And it was a pleasure. It's my first time.
Yes,
before I
thank
took here. Judge Hood. Nice
Thank
to
you.
meet you.
Thanks so much.
The case is submitted. Thank you both.